Welcome all to another edition of Legal Tech Week, the show we bring you every Friday afternoon, or almost every Friday afternoon anyway. We talk about the top news out of the week for legal tech and legal innovation. Today is February 21st, 2025. Reminder, you can find all of these up on LinkedIn. Just search for Legal Tech Week on LinkedIn. We've got the whole archive going back to 2020 or whatever it was that we started these things up there. A few weeks missing here and there, but most of them are up there. And you can also listen to this as a podcast if you prefer not to look at our faces while you're listening to us. You can do that as well. I'm Bob Ambrogi. I have a blog called Law Sites and a podcast called Law Next. And our panelists today, let's go around and introduce ourselves. Julie, want to kick it off?
Yes, I'm just bathing in victory right now, drinking from a U.S. mug because these are your tears from the hockey game last night. I'm Julie Shaboali. I'm a Canadian legal tech journalist. I write for Canadian Bar Association, The Walrus, and other Canadian publications. Good to see you all.
All right. And Stephanie.
Hello, everyone. I am Stephanie Wilkins. I am the Director of Content at Legal Tech Hub and originally from Buffalo, so I'm kind of like half Canadian. I'm kind of like with you, Julie.
Okay. And someone who's not too far from Canada, Niki.
I am not too far, and I think we're having our first real winter in years. At least we are over here in upstate New York. My name is Niki Black, and I am the Principal Legal Insight Strategist for Affinipay, parent company, My Case, LawPay, DocketWise, and CasePeer. I also have probably the longest introduction, and don't worry, I'm not done yet. I write legal tech for the ABA Journal of the Law, Daily Record. I also oversee and author the legal industry report that we put out on behalf of Affinipay that's coming out next month.
All right. Can't wait. And Steve.
Oh, hi, I'm Steve Embry. I write the blog Tech Law Crossroads about legal technology and innovation. I also regularly write for the Kentucky Bench and Bar magazine on practice management issues. I write for One Legal Blog, and from time to time, I also write for Above the Law. And I am co-chair of this year's ABA Tech Show, which is coming up in early April in Chicago. Not quite as long as yours, Niki, but I'm working on it.
And
I'm
we're
going to dig out some old awards or something that I got in grade school. I'm also the winner. I got a participation award for.
We're starting a GoFundMe for Steve so he can get some books for his bookshelves back there behind him.
Right.
It's looking a little barren. And last but not least, Joe.
Joe Patrice from Above the Law and Thinking Like a Lawyer. I'm here in New York. I'm dressed up a little bit more than usual, but it's because I feel like it's time to start classing up this show more. That's why I'm going to be in a suit from now on.
Are you suggesting we are not classy enough for this? I don't know. All right. Well, last week we ended with kind of a Doge rant that didn't really have anything to do with legal tech. So this week I thought, let's just get the Doge rant out of the way right up front because there's another story. And this one actually has a legal tech angle. So it's a legitimate story for us to do. Joe, take it away.
So I think this actually is confirmation of how last week's did have a legal tech angle. The concern of last week's was that a series of government agencies are now turning over their control of their operations to somebody who seems to have, and a team who seem to have no clue how tech works. And I suggested that was going to be a problem for legal functions. We have now, unsurprisingly, it didn't take long for me to be proven right. The report coming out is that the SEC had its Westlaw subscription canceled by the good folks at Doge. The reason for canceling the Westlaw subscription is comedic. It begins with Reuters, the news agency, saying something that Trump didn't like, which prompted Elon to say that Reuters was involved in a long-term social distortion project for the DoD. What that actually was not Reuters. It was a subsidiary of Reuters that are cybersecurity analysts who are working on helping the DoD, with avoiding and protecting against a long-term social distortion project. Anyway, they fired those people because whatever. And then they moved on from that into sending out, there's now circulating, the State Department got one, presumably other departments did too, cabinets did too, that listed a series of publications that are now to be pulped if they are within any government office. They include things like The Economist, noted left-wing rag, The Economist. They once said that city sewers were socialist, but whatever. Those folks, but also they list Reuters on there. And then soon after that, connecting all of these dots, we learned that the SEC was told that Doge bragged that they had cut Thomson Reuters big contract with the SEC because the SEC was giving this left-wing media organization $10 million a year or whatever, which was in fact their Westlaw subscription and all the affiliated Thomson Reuters projects. Because all of these companies may have a relationship to Reuters, but they are not all in fact Reuters. So now the SEC is operating, it is a very Lexus-y world, I guess, over at the SEC right now.
I'm actually, this is a genuine question. So I was actually surprised by how low the cost was that we're charging the US government. I'm just being really honest. The first time I read the story, I was like, really, only that much money for all, because I'm assuming this is for all federal employees, or is this just for DOJ, or,
I think this is just the SEC. So they're independent. Well, for now they're independent. I guess I shouldn't say for long. They're already petitioning to get rid of Humphrey's executor. So maybe they won't be independent for long. But for now, they're independent of the Department of Justice. It's not a huge amount, but yeah, the SEC is not quite as big, and it's possible that they don't have access to all. They might be paring it down and only have access to stuff that fits the securities needs that they have. But yeah.
What about, there's a contract in place here. Did anybody talk about what happens there? They're going to owe them the money regardless, aren't they?
That's the entire conversation around all of this Doge stuff, right? Like all they're doing is canceling contracts and claiming that they are savings. It is unclear how they're savings for the government to just renege on contracts, but yeah, that's the whole fight that's going on, right?
And
so
it's irrelevant and resistance is futile. I don't know where you're coming from, Bob. It's a new world, like.
Well, you can cancel a New York Times subscription, and that's a relatively easy thing to do. But these Westlaw subscriptions, these deals, I've seen these contracts in the past. There was one year when somebody went and somebody exposed all the Westlaw contracts with DOJ and whatever, and they were just crazy amounts of money. But
yeah.
They're long-term contracts, and they're not just cancelable like that. So I don't know. Yeah, I guess just something else to keep the courts busy.
You're applying logic, but also remember, there's only two people in this country that can interpret law anymore, and I think they think it's fine.
They've decided it's fine. Well, and look, this has bigger reperepercussions. Now, I haven't talked to anybody from TR, not that I think they would necessarily want to say anything about this at this juncture, but a lot of TR's market dominance in this space is because they are kind of for years, they have been the preferred go-to of the federal court systems, their research option that they like. And now we have the SEC is important, but not necessarily the biggest fish. But one assumes that if they're doing this at the SEC, the DOJ, CFTC, et cetera, are not far behind. What happens to TR when the federal government stops using that's an important segment of their business, not just directly, but also because we all use Westlaw so that we can have the same WL number that the court cites, right?
Does anyone remember the good old days when Westlaw used to fly judges on all sorts of amazing junkets all over the world and give them all sorts of extraordinary gifts and everything else? Times are so much simpler than we could just be corrupt and.
Yeah. I
So I
mean,
guess this is a boon
Wait,
for
wait,
LexisNexis.
you're implying that like the
There's
corruption
still
is
plenty of
bad. What are you
corruption. It's just
talking about?
different.
So we're all chiming in just to say, now wait a minute.
No, we all pause for a second to be like, is
Yeah, well, that
this
didn't come out right, I guess.
The corruption is still ongoing, Bob. We promise.
Good.
I would think there is, just thinking about conversations I've had with people in the past as well, that there's some sort of penalty, like for contract infringement. The government may not care, but boy oh boy will Westlaw care. I don't think they will quietly say, oh, okay, goodbye, $10 million. We, SEC, we're all good. Like I just think this isn't the end of the story, just knowing the culture of that company.
Well, there's so
sure,
many of
but
these things that are going to end up in litigation. They're going to cost a whole lot of money, and then the outcome of the litigation is probably going to be not only, enforcement of whatever the terms of the contract were, but in some cases maybe damages beyond that, or interest, or whatever, beyond that, and it's going to end up costing more than it would have cost in the first place.
but that's why this whole concept of the courts and the rule of law is a little bit of a mind F. I mean, it's because at this point we're at the
You can
point
say
right
it on
now.
this show. It's okay.
We're at the point right now where enforced against who? Like the courts are gonna, what are the enforcements? It's either like damages, but the damages have to be collected from the government, and that's who's being sued. And if Trump if says they don't have to pay, how are they going to enforce it? And who are they going to jail? If there's some sort of criminal contempt, or civil contempt, I mean, who's going to get put in jail? And like, what does that look like? Like, who are they jailing? I don't know. Who's the person from the Trump administration or whoever's getting sued that's going to get put in jail under a civil contempt? So
I am fairly confident it's JD Vance. I think that's the only reason he's there. He's not there for any other purpose.
We're assuming enforcement. We're assuming that we're all still playing the same game. We're all in the same, we're all still playing chess. They've like thrown the chessboard into the shredder, and like we're all like not even, it's a completely different ball game. They're over there playing, I don't know, cricket. I have no idea what they're playing, but it's not chess, and we're playing chess.
I will not let cricket be slandered here. But for any other cricket fans here, I will say you're making valid points, and it reminds me of the different types of litigation that have gone on in Canada regarding Indigenous groups who sue the government for treaty agreements that are still enforceable by law. And so why would you sue the government who is not doing anything in the first place? And I think of other types of litigation that have happened in the U.S. I remember giving a presentation about either it was Utah or Idaho. It's one of the Western states where the state government was using a program that was actually giving out less payments for disability payments because of the AI system that they were using. That went all the way to that state Supreme Court, and they're like, yeah, you can't do that anymore. So they're suing the government who is not giving out the money they're supposed to give out. So but they're the ones doing the wrong thing at the same time. So like, who's enforcing all of that? I do think it would be this is why I think it's important actually that Westlaw does try to enforce this contract. This is a constitutional crisis rule of law issue. If a legal publisher gets a cancellation of a contract without notice, and all the things that we all know from contracts law, and they're just like, well, we're afraid, so whatever. I think that's a very powerful message, not only to the legal community, but to the public, that a legal company whose business is to offer services about case law and legislation is like, oh, no, we're good. It's okay.
Easy for you to say up there in the 51st state.
God.
All right. Well, maybe this is a good time for JELL-O.
I mean, it's always a good time for JELL-O. This
It's
is
always-
Sarah,
it's
and
always
Sarah
good.
is in the audience, so
We
I
do
feel
have
like,
we have the author. We have the JELL-O author.
I know. I don't want to. I can never step in for Sarah unless you want. I mean, I can totally talk about it.
Does she want to?
So wait, this is it. The argument is that legal tech is like JELL-O in that like
Yes.
occasionally its most public face gets criminally charged or something, or
You did not read the piece?
No,
Did you not
I
do your
just
homework, Joe?
have we reached the point where Cosby jokes aren't things people get anymore?
Oh, no, I didn't get that.
Okay, yeah, okay.
But yes, this is the JELL-O theory of legal tech.
Yeah, so the way this came up is, so the Contract Pod AI came out with Leo Marketplace earlier, which is basically a place where people can play around and build things with Leo, right? And like it's sort of like an app platform, app store sort of thing. And so I just sent it around to our list, and then Sarah, being the one and only Sarah, was like, "Oh, I love this. It totally reminds me of like JELL-O and how that became popular." And I was like, "Sure, it does. I feel like that's something you should write about, Sarah." So she did. And basically, and I learned a lot about JELL-O in this JELL-O, which is fascinating, and it is a very good analogy. But hopefully I can get this right, and Sarah can correct me in the comments if I am wrong. But so the whole idea of
Or
it
she
is
can
that,
speak up if she wants to. She's welcome
yeah,
to join
Sarah,
in.
raise your hand
if you
you
want to
Sarah, do you want to talk
go
about it?
on the record. Go ahead.
I don't hear her raising her hand. But so back when gelatin was first a thing, before it was the name brand JELL-O, oh, sure, she said sure.
Okay.
All right. That means that's the
Totally
challenge
worth
to
it.
me now.
She will
having to
explain
figure
it
out
so
how to
much
do it.
better. I will, in the meantime, I will put the article link in the comments because it
Oh, I
is.
know what I have to do. All right, you can start while I figure out it. Are you?
I'm putting, here it is, here's the link.
On my list
But
here?
yes, so the idea being that gelatin when it first came out was very expensive to create and very hard to use, and it was really an upper class sort of thing. And then when JELL-O made instant gelatin and it should have been easy, people still ignored it because they were like, well, I've never had gelatin before. I don't need it. I don't know what to do with it. Why do I want this? And rather than giving up on it, JELL-O was like, no, we're going to make people understand. So they gave out free cookbooks. They put all these things in people's hands to get JELL-O out to the masses so they could understand what they could do with it. And perfect timing, because then Sarah can actually do her analogy justice.
Hey, Sarah.
Hello. I was not expecting to be on camera today, but
You would have
Well,
brought
only
JELL-O.
Joe is in a suit, so you're fine.
yeah. So as Stephanie was saying, again, like the LTH group chat is obviously the coolest thing in the world. And
Not at all
it's
unhinged.
just some of it, Stephanie's and I's like chats never become from public. It's just
Yeah,
we'll never
cooler
be
than
able
our
to show our
chat
face
here.
again with how uncool we are. But anyway, so so what I was thinking, so gelatin is a long-standing product. Like people in the 1400s were making gelatin products, Henry VIII, all that fun stuff. And then in the late 19th century, early 20th century, they made instant JELL-O or instant gelatin, and they released it, but like no one knew what to do with it because they were living fine without it. You know, it was a very much a high-class product. They didn't care that now it was faster and cheaper to make. They didn't ever use it before. They don't need to use it now. And so JELL-O started sending cookbooks, you know, and when I was looking more into it, they also sent out like free like molds. And once people got the idea, like, oh, I can start, this is what you do with JELL-O. This is how I can like fit it into my meals. And then it really took off. And now like everyone in the Midwest, you just always eat JELL-O all the time. So that's what made me think of it. And you know, start off because, you know, I kind of remember like, I don't know, 15 years ago now, like when Carl Malaman like released all the data set of federal case reporter data that he had rekeyed, and like no one used it. And that's what's like, well, yeah, of course no one knows what to do with it because we've never had access to this data before. So it's, you know, when you are using a new tool, and so that's like with generative AI, it's not like, oh, here's a new content source I can use, or here, this is like just making an existing process faster. In some ways, it's a complete reimagining of like what you're doing as a legal professional. And so I think people kind of need some guidance into how to do things and just like, oh, I can model this and then I can kind of riff on it. So again, also another analogy you could use, I played music a lot growing up. And then like, once you get used to the fundamentals, then you can start playing jazz, you know, so then you can start just like riffing and you know, like what it's supposed to sound like and what the, you know, standard way is, but then you can start riffing on it and playing with it a little bit more. So
And
that's
so,
what
and so she,
was, but again,
and so she was
one of
pro
my
Leah
non
Marketplace.
sequiturs in the group chat where they're like, sure, yeah, JELL-O, of course.
And so she was pro Leah Marketplace because it's like the JELL-O cookbook.
Yeah.
Yeah.
Yeah. So, yeah.
And she
I
put
think
some really great links to photos of like hot dog JELL-O and things in the article. So, you know.
And you know, so our workplace is like not all American. So really, as is the legal tech world, is not all American. So it's kind of like one of those like, what?
Yeah, our workplace is very not American. And like everyone who is American, we're almost all like Midwest. It's very strange.
Yeah.
We're like JELL-O molds.
So I love the analogy, and I always love everything you write. But it was like I was also thinking though, well, yeah, but JELL-O wasn't like quite threatening the livelihoods of cooks all over the United States, whereas a lot of lawyers are still looking at Gen AI thinking, this is going to put me out of a job. I don't want this stuff. I don't even want to touch it with a 10-foot pole. I mean,
That's true. I think
there's
still coming from
that
the
part to
ABJ
it.
world where it's people who could never afford gelatin before are suddenly able to use it in ways, and the nonprofit world more. Yeah.
Yeah.
It may have put some gelatin companies out of business, though.
May have put some gelatin companies out. Yeah, and it definitely changed the nature of as you said in your article. I think church socials and whatnot for eternity. Never to be the same.
Yeah. So you can all understand why when in our little chat, Sarah was like, "Oh, this reminds me of JELL-O." I was like, write that immediately, please."
Yes, I love the analogy as well. I love the Midwest flavor of it, Sarah, as you know. And explaining to people JELL-O molds. I actually think it's, you know, this idea of any new product, there is somebody that is thinking it's going to take my job. And so I'm sure there were gelatin producers who were like, you know, now this is cheap, and also mailing free cookbooks. You're telling me there was no publisher or anyone who does that for their livelihood was like, oh, I don't care that they're mailing free cookbooks to people. You know, sure, everyone loves a free cookbook. I do think this narrative of you know, the fact that tech is going to take away lawyers' jobs, I think that has evolved a little bit. Maybe I'm putting more credit on lawyers than due, but I feel like that's not the conversation we're having anymore. Like, I think it's more of a, how do I want to use this technology that serves a certain purpose? I'm not saying it doesn't have implications in terms of the job market, but I don't think that's the conversation. I think your analogy, Sarah, is really spot on. It's more of, I never had this JELL-O to play with before, and now I also like cherries. See, I just kind of like vibe with the story in so many ways. But like, I can try the different flavors and the different molds, and you know, which church social should I bring which mold to, and Thanksgiving dinner. Like, there's just, the analogies kind of riff on themselves, because I do think that's where we are right now. I don't think our conversation is, do I want to try to make the gelatin? It's like, what kind of molds do I want to do? What kind of recipes do I want to make? So, which I think you said it better than what I'm saying, but
I was also gonna say, it's probably not like existing gelatin makers went out of business. It was like the people that did the other desserts, like those that we could replace it with faster, cheaper JELL-O, and we didn't have to have, you know, puddings or
And also, like, do what you want with the hype cycle. Everyone has predicted where we are on it, but initially there was so much hype, and I think some people were really quick to be like suddenly in this trough of disillusionment because people were like, "Oh, let's throw AI on everything. It's great," and then suddenly we're like, "But I don't know what to do with it." It's like Sarah says in the article, like people can't imagine how did you put it? Can't
imagine the impossible, I think, or something like that.
Whereas
Yeah.
some people are like, "Oh, cool, I'll just throw AI in it." And then once they realize it actually might take a little bit more thought than that, they're like, "Well, then I don't know what to do with this. This isn't doing anything for us yet." So I think to putting it in the hands of people, you need to push them over that step. And I think that is exactly the point of the article, because I think it was way too early to be disillusioned because the tech was way too new.
Yeah. I mean, and for me too, like my initial problem with using AI in my life was that I'm a control freak, so I don't like to delegate stuff, and I do like to do things the old-fashioned way. Like I drive stick shift, and I don't like, I use like a hand whisk. I don't use a blender if I don't have to. And so just the idea of like, some things I don't care if they're not the easy way, because I like doing it the hard way. And just the idea of like, oh, okay, I can do it like that. Finding ways I can like add AI into my workflows, and like, oh, and I can still do like the annoying stuff that I like to do that kind of make it the way I like it. But yeah, but that's the thing, you kind of need like that practice and like the getting in the loop of doing it and getting some muscle memory down. Then you can kind of riff and see how it then maybe fits into your life.
Yeah, and that's why, like you said, probably the people who lost business during this time is the ones who made other desserts, right? Like lawyers being control freaks? No way. Lawyers liking to do things in a longer process because they like it. Like, yeah, calling out all those dictaphone people out there. I know y'all still exist. Like, absolutely. I think that's really, makes me think of people who like to make desserts a certain way, because JELL-O is a quick and easy, right? And delicious and all that, but it's not making sourdough bread. And so I really think that's touching on this cultural aspect of lawyers just being like, I don't want to change how I do things. We're so slow to adoption, but at the same time, I think we've done a good job. So I encourage you to write more articles that use food as analogies for using technology. I think that's the lesson here.
Not just food. I'll have to share with you the one she wrote about cows, what she learned about legal tech from a cattle farm. Like every Sarah analogy is like, yeah.
I love the JELL-O one more from, I love everything about it, but one thing it's making me think of both as I was reading it and as we're talking about it is the marketing angle, because I have sat within marketing in a tech company for almost 14 years now. And as I'm thinking about this, the JELL-O company, it was a JELL-O Inc. I'm not sure who owns JELL-O, but they really did turn marketing on its head in a way that was significant, right? By like sending out cookbooks, by convincing people this was a quick and easy dessert. And it makes me think a lot of my grandma for two reasons. I referenced in the comments how she would always bring these unbelievably weird concoctions to every family event that she literally would throw like leftover salsa, leftover vegetables, and no one would touch this stuff with a 10-foot pole. We'd dump it on our plates and we wouldn't eat it. But then I do remember when she was about 94, and this is an example of their marketing. She was living by herself still, and all she ever ate was cans of soup and JELL-O. And I was like, Grandma, like, why are you constantly eating JELL-O? She's like, it's a wholesome food. She was a retired nurse, by the way. It's a wholesome, healthy food. I'm like, Grandma, it's sugar. Like, what are you talking about? Like, and that when I was thinking, like, where did she get that idea from as an educated woman who had a health background? And it was the marketing from, the JELL-O marketing back when she was, 15 or whatever it was, whenever this stuff came out, that she still believed as a somewhat senile 94-year-old woman or whatever she was, that it was a healthy, wholesome food. Like, that's some incredible marketing if you think about it. So, there's some marketing lessons to be learned there from JELL-O as well. So
does Gen AI need a Bill Cosby?
Yeah, that's the lesson that you learned. That's a good pull. Bring it all full circle there. Yeah.
Just have Cosby in the show twice in one episode. All right. We will move on from JELL-O to something. Sarah, do you want to stick around, or do you want me to
demote
you?
Really heavy, the nation's falling apart conversation too. Let's bring Sarah on to talk about JELL-O.
Oh, I mean,
cheer up, everyone. It's okay.
We need it. Have you seen our like bear episode? We don't only want to talk about doom. Like, talk about.
Yeah, and I also read your cow piece. I subscribed to all your stuff. And I think I once even called you the Kurt Vonnegut of legal tech writing or something like that. But
yeah, it was very cool, actually.
Although I don't know that the JELL-O essay quite applies. But
Dessert of Champions.
Breakfast of Champions. There you go.
Yeah, dessert. Yeah, okay.
Yeah.
I'm working here. I'm trying. I get nothing.
All right. So. Sarah, do you want to stick around, or do you want me to demote you which is I think what they call it in Zoom, not
you can demote me. I won't take it personally.
Privilege. All right. Let's see if I can.
Actually, while you're working on that, since you mentioned
Change
Zoom,
panelist appearance.
I'll take this opportunity to talk about, because we had this in our internal planning conversation, my favorite joke of the week, which is Microsoft will literally invent a new form of matter rather than fix Teams, which somebody put on Twitter, and I think is the best joke of the week. So congratulations. I can't remember who wrote it, but.
Oh yeah, I also immediately shared that within the LTH Slack or the LTH chat. Yes.
Yeah.
Mm.
All right. Bye, Sarah. I'm demoting you now. All right. So let's see. From JELL-O to, how about from JELL-O to KPMG? Just to go for some stark contrast.
Yeah,
To
the big
jiggle it up a
four.
little bit. Jiggle it up a little bit.
Jiggle it up a little bit, right? Well, this was a kind of an interesting article. Came from.
Aren't you glad I raised that?
Yeah, came from Bloomberg. A reporter at Bloomberg. He talked to this KPMG, the global head of legal services for KPMG, and in the past, the big four, if they were ever asked, do you want to compete? You're not competing with law firms, are you? And they would say, oh, no, we just offer a little piece to help them out. We're not going to ever think about taking their business. Well, so then KPMG files the application in Arizona. And then this guy, I swear, he just threw down the gauntlet and he said, yeah, we're coming after you. We're going to take legal work away from you. You're inefficient. You cost too much. You don't. Your business model, which pays out all the profits at the end of the year, means that you don't invest in technology like we do, and we can do these things better, cheaper, and faster. And we're going to do it. And tough. And this guy was a former Linkletter's partner, and it was really kind of scary in a way that they see these things, and so the big four has so many tentacles out there and reaches so far into so many businesses that they, if they put their minds to it and get rid of some of the restrictions, they could do a lot of these things. It's interesting that what he doesn't say is that not only do law firms not invest in technology because of the way they pay their people and the way they distribute profits, but they don't invest in technology because that might affect the billable hours to some extent. And so that's yet another piece of it. So, and he put it in an interesting way. He said, well, there may be some displacement as a result of this among law firms. It's like when the doctor says this is not going to hurt very much. Don't worry. There may be some slight, whenever the doctor says there may be some slight discomfort, it's like it's going to hurt like holy hell. So that's what I read when I saw that there might be some displacement. I thought, well, yeah, right. I bet there will be some displacement.
This overlaps with your blog post too. I included it in my newsletter, my LinkedIn newsletter this week. But I loved your blog post too that talked about remote work and law firms. I think that was your post this week, but it also
Yeah.
you also touched on some of those issues about the billable hour, and I thought it was really interesting. You should have included that too. Everyone should go read it if they think it was a great article.
But the interesting thing about it is that so when you distribute all the profits at the end of the year, that means as an owner of a business, you're not really investing in the business, right? I mean, you're taking everything you can out, and it sort of makes it like a glorified office sharing arrangement with a lot of lawyers. So the point I made in the post that I was making about remote work is, yeah, it would perhaps be better to allow particularly younger lawyers to have more flexibility and work remotely, but partners don't want that because they want the convenience to be able to just shout down the hall and say, "Get in here! I have a project for you, and I need it right now. You're going to stay all night." I mean, they want that for themselves, and maybe they're entitled to it as an owner of the business, but they're not thinking of long-term best interest of the business necessarily, because you morale goes down, you lose productivity when you're forced to do things that you don't like doing. And So that was kind of the point. I mean, and yeah, I thought about it when I read this, that not not investing your profits into the business and paying them all out, it inevitably leads to sort of this, well, it's my business and my clients and my branding, and I just happen to work in this spot where there's other people, kind of thing. And it's exacerbated now by the fact that, we're into this sort of free agency world of lawyers with law firms. They don't like it. They don't get paid enough. They don't get what they want. They leave and go someplace else to somebody that will pay them. So it makes it even worse.
I think it's interesting that the Big Four are talking more openly about the fact that that's been kind of their dirty little secret for a long time, which is they've been practicing law for a long time in this country, and they don't call it that, and they go to great lengths to say we're not practicing law. But if you look at how many, I don't know what percentage of their professional workforce is made up of lawyers, but it's a high percentage. And the work that those people are doing is essentially legal work for their clients, in some cases, pretty sophisticated legal work. The fact that they've now applied for an alternative business license in Arizona, maybe that makes them feel a little bit freer about talking about it. But I think the fact's been right. It's interesting that the Supreme Court in Arizona has kind of put this on pause a little bit, seems to be investigating a little bit. But
Yeah,
can't
I
imagine
wondered
they'll
when I was
ultimately give
reading
them a
these.
license.
When I was reading these comments, I was sort of thinking, I mean, somebody's obviously going to show that to the Supreme Court. This is what these guys are really out to do. The other interesting thing is, as a former litigator, the litigators will often say, well, the Big Four can't encroach on our business because they can't go to court and make arguments and try cases and all that, which may be true. On the other hand, um, the litigators may just be part of a team that's quarterbacked and run by somebody in the Big Four. I mean, the Big Four would say, here's what you do, here's who you're going to hire, here's what we're going to get paid. And the Big Four person would have the ear of the client. They call that work kind of like a general contractor. Litigator would be relegated to sort of a small piece of the thing. I was I guess it was at Legal Week a few years ago, and an EW guy was there, and he sort of put it like this. He said, for us, for law firms, a legal problem is a legal problem. For us, a legal problem is a business problem that has a legal component to it. And it's a completely different way of looking at things that they are in a position to do because they supply so many business services as well as legal services. So
Yeah, all really good points. And I think your your blog post on remote work and this story are very well related. Because the other dirty little secret is, as high level as a workplace environment would be for the Big Four, is still better than some of the law firms. Let's just call it, like, I'm thinking of colleagues of mine and friends of mine who left big law to go work for one of the Big Four accounting firms, and they know that too because they've had so many lawyers work for them for so long, as Bob mentioned. So I think these two things are intertwined. Not only do they know they can come after the business in terms of the argument of culture and supporting your workers and supporting associate lawyers and all that, they know they can do it better. Mentorship, work-life balance, all these things. I'm not saying people who work at KPMG and Deloitte are working 35, 38-hour, 40-hour weeks. I'm not saying that, but I do know folks who have made that switch and have said, Julie, it is so much better, or I'm learning so much more. I can finally go do XYZ that I wouldn't have been able to do at the big law firm because of those problematic partners that you mentioned in your blog post. That's the thing that actually worries me the most. Not so, like, the fact that they're coming after the work that lawyers traditionally do, as you just explained, with litigators, not worried and all of that. They have so many strategies to get around that. It's already happening. Talk to anyone for any in-house counsel, right? They all know this. But the firm culture part, like, if you're a better workplace than law firms, that's a problem because we still do actually need lawyers working at law firms. And again, if you want to be the type of law firm where everyone has to come to work 5 days a week, say it proudly, say why, and then just recruit as you should. KPMG is not going to do that. If KPMG wanted to recruit me now, they'll say, Julie, you don't have to leave where you're living in Canada. We'll even figure out a way for you to work and serve US clients from Canada. Like they will bend over backwards. So that's the thing that worries me because I don't know if people realize they could become a sizable employer of lawyers in general of the profession once they start to expand their business model.
Yeah, the thing that kills me about, and I'm sure this happens at so many law firms that say, well, we will allow you to work remotely, just be in the office a couple of days a week. Okay, now it's time for, we're going to evaluate you and uh, see if you're going to advance in the law firm. Well, he really wasn't in the office very much. He should, he wasn't here 5 days a week like somebody, so he's not going to advance like some. I mean, and that goes on. I mean, it's just the way it is. So,
I'm
and
so
that's what
with
kills me.
you. Yeah, it's the whole bait and switch, or especially when people or they hire people being like, "Oh, we're hybrid," and then after you're there for a couple months, they're like, "Oh, well, now we're going to be 4 days a week. Oh, and now we're going to be 5 days a week." And I mean, so it's I'm totally with you, Julie. That if you're like, we believe in office is better, just stand by that and be like, "This is better. This is how we're doing it." Don't try to
Or,
fit
well,
one in with the
I
other.
don't, I don't know what works for the federal government. They're all being, oh, come back to the office. Sorry.
Just on a kind of loosely related, only because it involves a UPL question, is this a thing I did this week. I had a podcast with the guy, two of the founders of Upsolve, who I think they're a really amazing organization. If you don't know what they do, basically they have, as even they will say, they've created the turbotax of bankruptcy, enabling people who couldn't otherwise afford bankruptcy, which seems like an ironic thing to say, but in fact, it takes some money to go through bankruptcy and you need to get a lawyer. And so they've made it so that people who can't afford to go through bankruptcy can do it entirely for free through their platform. They have, since their founding, they've helped over 16,000 families discharge more than $700 million in debt, all at absolutely no cost to any of those people. They're a nonprofit. They do fundraising. They get grants. They take contributions, but don't charge their users anything. And one of the interesting sort of side things about them is this UPL lawsuit that they have going on in New York, in the state of New York, where just last year, maybe 2 years ago, I think they wanted to expand to they wanted to be able to hire basically almost like these limited legal like licensed technicians sort of people. I mean, just advisors who could counsel people on debt cases and in sort of small claims cases, debt cases, that sort of thing. And the New York Attorney General threatened to shut them down or prevent them from doing that because it was alleged that that was unauthorized practice of law. So they proactively brought a lawsuit in New York claiming that they have a First Amendment right to tell people about their legal rights. And they won that lawsuit in the federal district court in New York. It got appealed to the Second Circuit and was argued at the Second Circuit almost a year ago. It was like May of 2024. And the Second Circuit has yet to decide on that case. But it's a case that could really have some really interesting implications for UPL laws all across the country if the Second Circuit finds that there is, in fact, a First Amendment right to tell people about their legal rights. And why shouldn't there be? I mean, I'm no fan of the UPL laws. I'm not sure any of folks on this call are, but So Upsolve is a really cool organization. This lawsuit is sort of an ancillary thing. It's not core. It's not central to their core business, but it really could help open the door for other types of services to be providing legal help all across the country, depending on what happens with it. And on ethics, since we're on the ethics topic now, we moved over to ethics, I guess, a little bit. Not quite ethics, but UPL is close enough. Niki, you've got updates on that front.
Yep. And this isn't like earth shattering. One thing I try to do is cover ethics opinions that come down that intersect with technology. I've always done that. And Bob, when you used ChatGPT research, deep research, or whatever they call it, to analyze the ethics opinions, and it listed all of the ones that had been released, I noticed that I had not written about the North Carolina opinion because I wasn't aware of it. So I noticed that in your chart. And so I wrote about the North Carolina opinion, and it's not, this opinion's not earth shattering. And the opinions are all starting to sound similar because they're just looking at the analysis that preceded their assessment of the issue and typically following it. There are some jurisdictional differences. I just wrote a blog post about this for Affinipay and our legal products and their blogs. And, there are some areas where there are definitely differences. So you have to check with your jurisdiction to see where those differences lie. But there are overarching themes that are in common across all of them. And but the thing I think that's the most notable about this is it's more about the Texas one that I wrote about this week that's going to get published today. It's that there are so many of them coming down in such a short amount of time. And not only are there so many coming down compared to how the ethics committees and bar associations have addressed tech in the past, Texas's in particular is the second time they've addressed this. They had a report, a very lengthy 21-page report that was issued about AI in the law generally that covered an overarching range of topics. And now they have an ethics opinion on AI and ethical use of AI. And so it's just, this one state has addressed it twice in two different ways. So it's just, that's what's so notable. This is clearly, I think, a disruptive technology. And I've never used that term in all of my, the years that I've been doing this about tech. I've never claimed anything else was disruptive. I think it's disruptive. And I think that that's why you're seeing this just unbelievable number of ethics opinions and guidance and reports being drafted so quickly by committee. Things getting drafted by committee take some time, and they're doing it fast. And so I just think that's what's the most notable about it. And the reason I write about them is I think it's important to have these opinions covered, even though a lot of them say the same thing, and readily accessible through internet searches, and just so that people can find that information if they need it. And also just to highlight the fact that this is happening and it's happening so quickly.
Yeah, that reminds me, there's actually one other one that my AI research missed because I got an email from somebody, but it was, I think it was, I haven't posted about it yet. I got to add it to my list, but I think it was about, it was a guidance for judges as opposed to for practicing lawyers. But.
Yeah, I really love what you're saying there, Niki, about that this is actually disruptive because the volume is just unprecedented, and you can tell from the chart, and I have this bookmarked actually, Bob's post here, because the dates are so close together, right? And they're just coming out in such speed, and the same thing happened here, and it's happening in other countries as well. And it's just because this technology was available to everyone all at the same time, right? Like, not just to lawyers, but also to clients, and also to governments, and also to judges. And everyone just started using it all at the same time. I can't think of another type of email, maybe the only other one. So Suskin was right. Yeah. So maybe email is the only other thing that I can think of that was that disruptive, where everyone started using it at the same time. However, lawyers were still a little late to the game in using email. But I can't think of another technology off the top of my head. And that part is, to me, really disruptive. I also think I give kudos to the state bars for putting stuff out quickly, by the way. Like any kind of guidance, even if it's repetitive, really helps lawyers, because besides how am I supposed to use it, how do I use it and not get in trouble is usually like the first two questions, right? That any lawyer's going to ask you. And I really do appreciate that state bars are doing this pretty quick.
Like last year's ABA opinion on listservs, they were right on top of that one.
Thanks for the plug, Bob.
Another disruptive technology.
But are enough people reading the guidance? Because I feel like we're still every week getting another story about hallucinated cases and blah, blah, blah. And I'm like, I love that they're putting out all this guidance, but
Those
is
are
anybody...
competence issues, though. Those are lawyers that are incompetent to begin with, and they still would have been putting out. They still would had ChatGPT or AI not been around. The submissions that they provided to the court, if you'd gone over them somewhat carefully, even without that, would have had all sorts of gaps and holes in them, because that's the way they practice law. That's my
I think that's right.
Yeah.
They probably wouldn't have had, cases that didn't exist, but they would cite cases that didn't support the proposition. Yeah, that's been going on forever.
Yeah, it's just more of it and easier to find. I don't know. I just get so frustrated when I'm like, we've been writing about lawyers messing this up for 2 straight years, and they're messing it up in the exact same way.
That will continue until, like, for the next 5 years. I've given myself 5 years to be like, I'm going to be writing about people using this technology, and oh my goodness, there's a fake citation in there, and the judge caught it. I'm just settled. It's just gonna be like, oh my goodness, that the lawyer didn't communicate to the client efficiently and on time, and now the client has to bring it's just going to be another category. Niki's right. They're just incompetent lawyers doing things. So it's a new category in terms of like, oh, my lawyer didn't properly, to the extreme of the ones with trust funds and all these other awful ones and then check my work. So
I mean, be careful what you wish for. What would we have to talk about here if these things didn't happen?
Right. we would be somewhat in trouble at Tech Show if we couldn't talk about AI.
That's funny though. I mean, like, seriously, 3 years ago, what were tech conferences about?
I sort of wondered that myself.
I kind of have forgotten.
It started to get a little like, okay, we're all saying the same things over and over again. There was AI. That was the thing that people were talking about, just not to the same. But I think we sort of had gotten to a point where it's kind of like, okay, now what are we gonna, like, it's the cloud. We can't talk about the cloud anymore. What do we talk about, right? It was getting to this point where we're sort of stalled. The next big thing had to come, because what would we talk about at conferences? That's the whole
pivot
goal.
tables.
Somebody in the chat said cybersecurity, and I guess that's right. But none of the lawyer attendees listened to the cybersecurity apparently anyway. So
well, they're not listening to the hallucinations either. So,
but they should, and data governance and just and the social media, not social media, the marketing ones. And I know none of them listen to those either. But like, have a website, have at least one social media. Yeah. Now I'm a broken record again. Thank you to the person who's putting metaverse in there. That's I remember that.
and there was blockchain. That was a big one for a while. Yeah.
I miss blockchain.
You can have it. I no, I don't.
Yeah. All right. Let's see. We got a couple of things. One was the Stephanie, you had that piece on Deposely. I wrote about them too this week. That was kind of a cool thing. You want to mention that? Or?
Yeah, I thought it was really cool. So I actually met the founder or co-founder of Deposely randomly. We sat at the same table for lunch at CleoCon, so that's how I even was in touch with him in the first place. But and he was talking about the cool stuff they're doing. But so what they decided to do, because he was like an Amazon AWS engineer, so from general tech and not legal tech. And so basically he was like, we're used to seeing free versions of all this software, and then you get the more and bells and whistles with paid versions. We don't see free versions in legal tech. You might get a little, free trial period, then it's over. He's like, we're going to introduce free versions. So they put out basically a free version of the Deposely software which does all sorts of cool things during depositions and whatever. And I mean, I think one of the coolest things was it can tag or it can identify contradictions if someone's testifying or like impeachment opportunities. And so in the free version, you can put that in after the fact. For the paid version, you can get that in real time, which is cool. But they put out they started with one summary tool, and there's going to be, I think, like 5 of them in the next few weeks of just completely free for now. The plan is in perpetuity for anybody to use these deposition tools, which I thought was, I mean, we talk about access to justice a lot on this and free access to stuff. So I just thought it was a really cool move.
And I would note that when do we go to Filevine, Joe? Was that in the fall or something? When we saw their Depo,
Yeah.
what do they call it? I'm forgetting what they called their thing. Depo Copilot, which we were kind of blown
yes.
away by the fact that it could point out contradictions in testimony, inconsistencies in testimony in real time. This Deposely thing does that. Plus, it can pick out inconsistencies in real time against the documentary evidence you've uploaded. So it can say what that person just said is not consistent with what this document says about this or something. So I thought that was it's sort of taken that
pretty interesting.
Filevine thing a step further.
Yeah, just when I had that lunch conversation with Mitchell, I was like, no, this actually seems like a really, really cool product. And so we just connected on LinkedIn, and then he reached out and was like, we're going to have this free announcement. Like, who do I tell? So I'm like, tell Bob, tell. I'm like, tell people. It's really legitimately like cool free tech. I want everyone to know about,
Yeah.
So.
Yeah, it is cool. All right. Well, I guess that does it. Now Joe can now go take a suit off and put on some casual clothes, and we can all get started on our weekends, hopefully. Thanks to everybody for hanging out with us on this Friday afternoon, and hope to see you back next week.
Well,